in terms of FEG out the door, back in 2015, 2016, you were seeing 300 odd million out the door.
It's a huge number.
It's an enormous number. And obviously we saw a drop off over COVID because you had all the measures that the government implemented. You saw a significant drop off in insolvencies and as a result, drop in FEG payouts.
Sure.
I think we were sitting around 160, 170 million out the door over that period.
Cathro and Partners presents The Cut, a podcast about all things insolvency.
Hi, my name's Andrew Blundell. I'm a principal at Cathro and Partners, and welcome to today's episode of The Cut. Today we've got some very esteemed guests, two ladies that are guns in the litigation funding space. We have Rebecca Dalais and Courtney Macdade from the Department of Employment and Workplace Relations FEG Funding Recovery Team. Did I get that right?
It's a mouthful.
It is
yes.
a mouthful.
Nailed it.
Welcome to the program, guys, and thank you so much for making the time to come today. Obviously, I've worked with you, or both of you, on numerous files over a fair period of time. We've got some good results together and we love working with you guys, but it's always interesting to hear about what's happening in the marketplace, how you guys are seeing things. And usually in this circumstance, we try and start with a bit about you guys. Like, what made you interested in FEG? How did you come to be part of the FEG funding recovery team? Beck, maybe we can start with you.
Yeah, sure. Thanks, Andrew. So after studying both accounting and law at uni, I started off my career at Dalais in their insolvency and restructuring team. After a little while there, I decided to become a lawyer and I joined K&L Gates and worked there for 8 years. Yeah. But after that, I had 2 kids and I realised that I needed something that was a little bit more work-life friendly, but I still wanted to do challenging work. And I still wanted to strategize. I was always much better at strategizing than the black letter law. And I had worked with Steve Humphreys, who was in the recovery funding team at that stage when I started at FEG. He approached me and sort of said, well, I can give you the work-life flexibility and the challenging work. You can have the best of both worlds.
How good.
Exactly. And so that was 4 years ago, and that's what I've had at FEG that whole time.
Amazing, amazing. And Courtney, what about you?
Well, I had the privilege of working on a FEG-funded matter for about 3 or so years in private practice. So I was at Colin Biggers and Paisley, and we got right to the tail end of the matter and we signed up the settlement deed, and about a week or so later, Steve and Beck invited me out for coffee. And
of course they did.
The rest is history. So I think I'm a bit like Beck. I never really loved getting into the weeds, but I really love litigation. Yep. And so Beck sold it, Steve sold it as an opportunity to get involved in the strategy, get involved in sort of that the bigger picture stuff, sure, rather than drafting your 50 or 100 page affidavits and the constant letters and correspondence. So it's been a really good move.
Oh, I can see how that would be enticing. I obviously working with you guys on some of these matters, it's always interesting to get in the room, and particularly when we're at a mediation and go, well, hang on a second, which button can we push here? Have we got the big FEG stick in terms of the unlimited pockets of the Commonwealth? Can we push hard to get a result here? And that is exciting. It's not, you're not trawling through evidence and trying to put together briefs and do all of that stuff. You're thinking about the strategy behind it and how do we get the best return for the creditors that we're acting for, and obviously in your circumstance the Commonwealth in terms of the money that they've sent out the door from the FEG perspective.
Absolutely.
So from that side of things, obviously a big change recently. You've now got access to the super guarantee debt, and that's part of the remit in terms of you looking at funding particular matters. Tell me a bit more about that. How's that come about? Has it been something that's been in the works for a while? Or how did that all get to where it is today?
Yeah, it's always been a dream for us to be able to broaden the scope of the program and look at recouping SGC. It's as of the 1st of July, just passed, 2024, the policy decision has been made that we're able to recoup SGC as well as unpaid FEG. And so for that, it means that we're able to get involved in a lot more matters. We're not just looking at FEG in terms of commerciality. So if you've got a matter previously where the FEG was quite small but there was a large SGC, we weren't necessarily able to invest money in those matters. But now, if you've got $1 of FEG and a larger, say, a couple $100,000 of SGC, you can come and talk to us now. That's something that we're really interested in working with liquidators on. So, yeah, it's really exciting. There should be a lot more files that we can be approached on and get engaged in. So, yeah.
And we're really looking at it from two different angles. So we've got our internal team that's going through some of the older files, going back, say, 5 or 6 years, because obviously that's the limitation period on a lot of the actions that we fund. So internally, we're looking at those matters with FEG and identifying which ones have SGC, which ones have those claims that we might be able to chat about. But then also we're getting out there and chatting to liquidators and sort of encouraging them to also do the same and look through their files to work out if they've got any that, just might have gone under the radar because we just didn't have that remit before.
It's amazing. It's actually exciting from my side of things too, because there's a lot of behaviour that's changed since the FEG program came into play, and which is a great thing because it's putting people in a place where they know that there's a pretty good likelihood, if there's a decent claim, that the FEG are going to be interested in funding a liquidator to pursue it. So it's really good from that side of things, from a policy point of view for the Commonwealth and recouping some of the money that's going out the door. And it also puts people on notice in terms of the way that they're approaching restructures, whether it be people that are unregulated or people that are regulated, and the way that they're thinking about, okay, well, I can approach it this way, but if I don't pay the employee entitlements, I don't pay the super, there's a good chance that FEG's going to look at funding a liquidator to pursue me.
Absolutely. Absolutely. And that's one of the interesting sort of behavioural changes that we've seen in the market is that you get these advisors who are telling companies, well, look, FEG's going to go after you if you leave unpaid employee entitlements. So don't do that. But don't worry about the super. Don't worry about paying the super. They won't chase you for that. Yeah. So you see these restructures structured in a way, well, we see them once they've fallen into liquidation later on, where they're deliberately doing this process of leaving the entitlements to the Commonwealth. And then, a lot of these people don't even know that they're not being paid their super. So it sort of all goes a bit unnoticed. And we've even noticed, we've got production of documents before, and we've looked through the advice, that the advisors have been giving prior to the liquidation. And it's even referenced the FEG recovery program will go after you. Yeah. So it's blatant. It's not hidden in any way, and so it'll be really interesting to see whether that behavioural change it changes even further. To sort of, I'm not sure how they're going to deal with it if they can't leave the FEG and they can't leave the super. What will they do? We'll see.
It's very interesting, and to your point, I've actually been in a creditors meeting before where your active recovery guys or your active creditor team have said, can you please explain to me why you've left this particular employment entity out of your proposal? And it's minuted, it's on the public record. They said, our advisors said that FEG will cover the employee entitlement debt, so don't worry about it. And I just took a step back and kind of said, really, is that something you're going to put into the minutes? You're going to reference that in a creditors meeting? I just was absolutely gobsmacked. But obviously there are still people out there that are doing that, but for the most part, you're right, the behaviour has changed since the introduction of the program. And was it 2014, 15 that it came into effect? What have you seen over that period in terms of the impact that it's had, the recoveries that you've been able to recoup, and I guess the difference between what's going out the door and what's coming in the door from the active creditor side of things? Tell me a bit more about that.
Yeah, absolutely. So in terms of FEG out the door, back in 2015, 2016, you were seeing 300 odd million out the door.
That's a huge number.
It's an enormous number. And we saw a drop-off over COVID because you had all the measures that the government implemented. You saw a significant drop-off in insolvencies and, as a result, drop in FEG payouts.
Sure.
I think we were sitting around 160, 170 million out the door over that period. Last year, we've seen a significant spike, and so it's just going to go up and up. And I wouldn't be surprised if we hit around the 300 million again in this coming financial year.
Yeah.
In terms of recoveries, obviously there's going to be a little bit of delay in terms of the recovery opportunities.
Sure.
We're seeing them earlier and earlier in liquidations, which is fantastic. But I expect that they will follow that trend up, so that the recoveries will follow the increased FEG out the door. And the program itself, there are organic recoveries that come in every year. They always have. They've definitely increased, and that's a lot to do with the work of the active creditor team, working alongside practitioners to determine the appropriate payment of dividends, and they do play a really good role of being an active creditor in liquidations, right? But the active effort of our team, the funding and the active creditor team, the recoveries that we can directly attribute to the work that we've done is in the order of 286 odd million dollars over the life of the program, in addition to the organic recoveries. So we're expecting, it was a little bit quieter over the COVID period, and I think there were a lot of factors at play there, delayed court dates, and everything just sort of
slowed down a bit.
Halt, didn't it? It didn't slow down for us necessarily in terms of jobs coming in, like funding opportunities coming in. We had practitioners really going in, and they had a little bit more time on their hands. They weren't rushing around with all those big VAs.
Yeah.
And so they were going in and cleaning out all of the old files and identifying funding opportunities for us to look at. But we're expecting bigger and better funding jobs over the next couple of years.
So I think in terms of the quantum and also the number of claims, construction is by far the biggest.
Absolutely.
I don't think that's going to change. Then we also see retail, accommodation, hospitality industries.
Yeah.
But in terms of the recovery funding team, the claims that we're funding are all completely different. You know, you have your usual insolvent trade claims, preference claims, and claims under the Corporations Act that are available to a liquidator. But also we look at completely novel claims as well. So in all different industries. So it's really interesting.
Oh, absolutely, absolutely. And in terms of the funding space, you're a lot different to other litigation funders, and your model is particularly helpful to people like myself because it's not a for-profit model. So tell me a bit about that. How does that work in terms of if I have a claim, what do I do? How do I go about approaching you guys in terms of looking at getting something funded?
Yeah, absolutely. So we're in quite a privileged position in the FEG recovery team because we're not, as you said, for profit. As long as there's enough money to repay the funding that we've advanced, the money starts flowing in for FEG shortly thereafter.
Yeah.
And so that enables us to play in the sub $5 million claim space, and we quite often do that.
Yeah.
And in my view, there's a lot of really interesting law to be made in that space, and we're also able to support liquidators to pursue some pretty bad conduct in that sub $5 million claim space as well.
Yeah.
So we're always looking for matters where we can test law or we can support liquidators to look into potential Phoenix activity.
There's lots of stuff that you're doing in that space. It really helps us as an industry because it clarifies the parameters around this particular type of claim or that particular type of claim, or priority in terms of circulating assets or those types of things. So that's really helpful for us as participants in the industry, and it's amazing to see that there is not just a commercial aspect to it, but there's also a point of law and a clarifying things for everyone, really, and that's super helpful.
Absolutely. I think as a young lawyer, you have this wonderful image of going out and doing all these wonderful deeds when you enter the workforce, and I think we actually get to do that. We actually get to get involved in creating and clarifying law and also chasing down some of those bad guys. So it's a brilliant job and it's a brilliant program.
I was involved in the metal manufacturer's MJ Woodman claim that went up to the High Court to test the defence of set-off against unfair preference claims. And that was really... It was fantastic. I mean, to go to the High Court.
I was about to say, what is it like to actually go in there and look up at the bench, because it's quite high compared to everywhere else, right?
Yeah, it is. You're right. It's a bit of a surreal experience as a lawyer going to the High Court, and even better when you don't have to get up and present any case. You can just sit at the back and watch. But yeah, it's an institution, and you're sitting there, and there's no one else there. It's just the parties and anybody interested. But I suppose not many people outside of us are really interested in insolvency law. But you've got people filtering through the back of the court just in their gym gear, watching to see what's going on, and it's this juxtaposition between the preeminent lawyers and judges and all in this room, and then all these people going, oh wow, I'm going to pop in and have a look and see what it's like to go to the High Court.
A run around the roundabouts around Canberra and
exactly,
in the back of the
and just
High
pop
Court.
into the High Court. Yeah, so that's interesting. But we're also looking for things like opportunities to test the 2017 reforms around preventing the misuse of the FEG scheme. So things like transactions to avoid
creditor defeating dispositions.
Correct.
Yes, another mouthful.
Yes.
Also, we've been
contribution orders.
Yeah, contribution orders as well. We've been looking to test that. We'd love to find a case where we could test the safe harbour reforms as
everyone
well.
would love you to do that.
Yes.
Because it's obviously been untested for such a long period of time.
Absolutely.
That's right. And, from our perspective, there's only two avenues really. You either didn't have a proper plan or you had a plan but you didn't implement it properly. And so, you look at those two avenues and they should come up. They should come up more often. But I suppose we're still seeing those people using the plans and then using that defence to a claim.
Yeah.
And that'll take a little while to filter through. But they're definitely opportunities that we're looking for.
Yeah, right. It's the whole safe harbour piece is so interesting from my point of view, because it's an area where we're seeing and doing a lot more in it, and it's fun work for people like me too, because it's when you're in a position where there's actually some money that you can do a restructure potentially before some sort of formal appointment, and working through that process and actually having the funding and the runway to get to a point where you can do a restructure without potentially a VA or getting into some sort of formal appointments. Good fun, and the results that come off the back of it save some jobs. FEG doesn't have to pay any money out the door. It's all good stuff from our side of things, and I'd be interested to see when you do finally get a matter that you're looking to test the boundaries of that, what that looks like, because it'll give us some great clarification for the industry at large and I guess the community more broadly. So
Absolutely.
Yeah. I guess watch this space. Let's see where we get to.
Definitely. We'll get there.
You will. So I know we've worked on a number of matters with you guys, and two specifically that come to mind where we've been able to get some really good results really quickly. Tell me a little bit about your approach. Like, what are you looking to do when it comes to litigating on a file? How do you like to go about it?
So we are being contacted a lot more early in the piece. It used to be that we sort of got 2 or 3 years down the road and the liquidators would give us a call and say, all of this has happened and now we want to look at an insolvent trading claim.
Yeah, and you've got 5 minutes before your limitations period comes into effect. So
correct.
Good luck with that.
Correct, exactly. And we'd all be scrambling and we'd get there, but it was made things a lot harder.
Sure.
So we've really been encouraging, I suppose since COVID, we've been encouraging the liquidators to come to us earlier. So we're seeing them come to us even in the voluntary administration period and sort of say, well, look, this is looking like it's going to go into liquidation.
Yeah.
We think we've got all of these avenues of recovery potentially. How do you think you could help? And where do you think you could fund? Do you think there are any that we can go after on our own? And we'd sort of divvy up the pie, help you with the strategy, work out what the best approach might be. And then we can really gear our team up for what, as soon as it hits a liquidation, we can get in and get information from you, get it started with, get the ball rolling to really give you that funding and give you the support to get the recovery action started earlier. And obviously that has a huge impact on recoverability. If you get in really early, you've got the opportunity to freeze assets and shore up that recoverability piece so that it is more commercial to continue to pursue it.
Yeah, I love being able to pick up the phone and go, oh, hey, Beck, hey, Courtney, what do you think about this? This is where it looks like it's going. And like even mediations these days, you've got to a point where you've settled before PEs because you've got a strong claim. You haven't had to go down the path of spending a ton of money with the lawyers to get to a point where there's a settlement on the table. So tell me a bit about that and why you think that's the best way to go about it, your process. Are you open to having calls with creditors that are copping preference claims directly? Like, how do you deal with that?
I think so. We're in a lucky position. You've got the liquidator team and the legal team really getting in and getting their hands dirty with the legal issues. I think the liquidators, you guys are obviously, you've got the commercial outcome forefront of mind.
Sure.
But we can come in and we are looking at it from afar. We've got a different perspective on things.
Yep.
And we can identify opportunities to settle that perhaps you guys may not have thought about just yet.
Yeah, come across before. Yeah, Beck's raised things with me previously. Oh, have you thought about this? We've had a case here. You should have a look at this. Maybe consider that.
Absolutely.
Yeah.
And so we've got a lot of matters on the go. We've got about 60 files running at the moment, and we've run hundreds over the life of the program. And so we're constantly noticing these little bits and pieces, and we're finding that the better outcomes are those that are achieved early.
Yeah.
And it's often happening well before, as you said, the PE has actually been listed for like the actual examination's been listed. And before pleadings have closed even. So it's really exciting.
The earlier the better. You don't have to spend a whole amount of legal fees and liquidator fees and disbursements to get to the point where, you've spent $1.5 million and the defendant has to stump up the $1.5 million plus the amount that you were chasing them for in the beginning.
Yeah.
So really, the earlier you come to the liquidator to try and settle the claim, the cheaper you're going to get out of it. It's just numbers.
Yeah.
And that's, we say this is the cheapest that it's ever going to be because the further it goes on, the more you have to spend.
Yeah, and the longer it's hanging over your head, and you've got all the just the monetary piece, but the I guess the emotional piece that goes with that. And
correct.
I'm commercial. I have to be commercial. I'm there to get a result for creditors, as you guys are. So it's the quicker you do it, the easier it is at the end of the day to everyone walk away, and the result is a lot better than what it may be if you litigate for years. And like you said, they've got to pay $1.5 million in costs on top of the amount that they end up having to pay as part of the claim. So,
and it's still the liquidator's claim. So obviously we're not in control of the litigation,
Yeah.
but we can have those conversations with the liquidator and say, well, we're funding it. We don't particularly want to spend another $1.5 million of taxpayers' money and take on that risk.
yes,
Isn't it better for everybody to just move on?
get around the table and nut it out.
Yeah,
Absolutely.
Yeah, I've been involved in some mediations with you guys that have started at 10 o'clock and finished at 10 o'clock at night, but at the end of the day, we've got the result, right? So
yeah,
it's
absolutely.
that's exactly right.
it's good to be doing that rather than fighting in front of the judge.
Yeah. We were actually at a conference yesterday and the guest speaker was Justice Lee from the Federal Court.
And I did hear that you were fangirling over that.
I may have. I asked a question. I sort of said, well, look, we're doing these earlier engagement with we're doing earlier engagement with defendants and even proposed defendants.
Yeah.
And, he talks a lot about how to make the court system more accessible for everybody.
Yes.
Because even wealthy Australians cannot afford to just drop $2 million on going through the court system, and it's just becoming more and more inaccessible for everybody.
Yeah.
And he talks about, trying to find ways to streamline the litigation process. He talks about, using referees to determine insolvent the period of that a company becomes insolvent,
Yeah.
rather than two expert reports nutting it out, and everybody's spending so much money on experts and things like that. And I put my hand up and I said, yeah, this is great. This is what we're doing. We've been really, really trying to get people to mediate early and not use up the court's resources. But how do you deal with insurers? And so we've been really looking at that quite closely to work out, well, can we pull together all the information that an insurer might need to make a decision about whether they're going to the policy response
Bonds or not. Yeah.
and they're going to take responsibility, or do we have to go through this whole process and get to the steps of trial and literally be standing there before the judge saying, hey, can we just have an adjournment for 5 minutes on the start of the trial because we need to go and talk about settlement? It's just you spend all this money.
Effort, time.
Correct. So if we can bundle that all up at the beginning and give it to them and maybe they can make a decision earlier, then it saves everybody.
No.
It's just as much in their interest as it is in ours
Absolutely.
to reach an early resolution. So it just makes sense. And particularly when a funder like us are involved, it makes sense for us to try and use some different strategies to get them into the negotiating room sooner.
It's just something that everyone, like you said, if we can unclog the legal system, we can make it accessible for people. We're doing everyone a favour when it comes to that. So at the end of the day, everyone wins. And there's probably going to be a better, quicker return to the employees and to the FEG program in relation to the settlement that you get in any case. So it's a win-win for all there. I had one of your colleagues, Will, do a presentation at a credit forum last week, and Will was talking about the engagement that you guys are happy to have with creditors, particularly ones that may be the subject of a preference claim of someone like me that may be funded by FEG. Tell me a little bit about that and how you think that's going to work or does work in practice.
Yeah, absolutely. So we see it through the life of, so before commencement of proceedings, there's oftentimes directors, creditors who are being pursued by the liquidators wanting to understand the role of FEG in the matter. And we don't shy away from having that conversation. So
You've got to.
Absolutely.
Yeah.
And so we've had directors in the past reach out to us and just say, look, you're the Commonwealth. I want to explain where I'm coming from here. I didn't necessarily do the wrong thing. Can you just hear me out?
Yeah.
And like liquidators, you guys are really well positioned in litigation because I don't think there's not a lot of emotion involved from your perspective.
Yeah.
This is a numbers game. We're trying to get money back in
Yep.
to a liquidation so that you can pay creditors.
Yeah.
But there is that emotional aspect for the defendant, particularly directors who've been involved in a collapsed company. It's their business,
Oh,
right?
it's their life.
Absolutely.
It's hard not to be emotionally engaged if you're a human, because we're all humans. We all have feelings. We all have all the stuff that goes with that. But yeah, at the end of the day, you've got to give them the opportunity to voice their view, right?
Absolutely.
Yeah.
And if we can play a role in that, then we're absolutely happy to do that. And we see it in mediations as well. Beck and I had a fantastic mediation a couple of weeks back where the lawyers for the defendants came into the room and said, can the liquidators and FEG please come into a room with our clients?
Yep.
They just want to explain where they're coming from. So we're happy to do that. Absolutely.
Yeah.
And we've had, again, creditors being pursued with preference claims. We're happy to explain what the law is trying to do. Because oftentimes, I think with preference claims in particular,
Yeah.
they don't understand. They perform the service, they did the work, and they receive the money, and now it's being clawed back from them.
It's one of those things, right? Like they're getting the rough end of the stick, for want of a better term, for good collection practices at the end of the day. So it's, do I get paid? Do I pursue that? Do I not pursue it? How do I go about it?
Yep.
It's it kind of, it is the law, and it's part of what we have to deal with. But at the end of the day, it kind of almost feels like unfair.
Absolutely. Yeah, there you go.
There you go. No pun
It's in the
intended,
name.
right? Yeah.
Yeah, exactly. So, as I said, we're happy to play that role, and we've seen a lot of success with it in the past. And obviously, with the support of the liquidators, if we need to have direct conversations, we're happy to do it.
Well, I can vouch for you both. You're not unhuman. You're very approachable people, and I think on the back of Will's presentation the other day to that creditor forum, people were actually pleasantly surprised that they have the ability to do that, and I think it was good from a perception point of view from their side of things, as well as an understanding from your side of things that's achievable. And yeah, like I said, you're not ogres. I can pick up the phone and have a conversation with you, and so can everyone else, which is great. And that's the way that it should be approached. And kudos to you guys for going about it like that. I think, is there anything else that you wanted to touch on today? I know you've given up a lot of your time. You've got planes to catch at some point soon, but I just wanted to make sure that we articulated some of the successes that you guys have had, the approach that you have towards the funding, particularly for people like us. I know there's co-funding opportunities that you guys also are happy to look at, and the other side of things in terms of early settlements and trying to be available to hear our directors or hear our creditors on their points of view. So, I mean...
Look, I think we say time and time again when we're speaking at presentations that we do or to liquidators directly, we're extremely flexible. So I know that when people think of a government funder, that perhaps we're quite strict in the way that we do things, but we pride ourselves in being able to fund any part of a liquidation that you need support with to be able to get a recovery outcome.
Sure.
And so we can fund that $10,000 fee that's going to be able to pull down some documents and put them onto a server so that you can search them. That's something that we can provide support for. We can provide your indemnities. We can tailor it to suit your needs. And we're also happy to work with, I know that we've done creditor, so we've done co-funding with creditors.
Yep.
We've co-funded with other government departments, and we've co-funded with private litigation funders. And in each of those scenarios, we've had really good outcomes.
Yeah.
So I think it's about I just want to communicate how flexible we can be.
Yeah.
And we don't have to fund everything. So we can fund your disbursements, or we can fund just the barrister's fees, for example.
Yeah.
It's,
There's a lot of
you just come to
flexibility.
us and you have a conversation. We figure something out that's going to work for your matter.
Yeah, no, that's it's good, and I'm not sure if the marketplace in general understands that. I know people that work with you guys love working with you guys because of that flexibility and the results. But I think there's still a bit of a misconception in the broader marketplace that, well, hang on a sec, FEG's going to be difficult, or this is going to be that, or so it's good to reiterate that for everyone listening, that FEG's not there to make it problematic for anyone. They're there to recoup funds for the Commonwealth and to do it in a commercial manner, but also taking into consideration what other people's viewpoints are and getting to a point where you can get to a result that satisfies or somewhat satisfies everyone, but is the right result at the end of the day. So,
and we're a resource as well. You know,
Yeah.
I was speaking to someone yesterday who said, oh, I had these claims and I talked to you guys about it and I couldn't get any funding. And I said, oh, that's disappointing. How did you go? And he said, well, actually, I ended up getting a really good result because when I rang you guys to talk about the claims, you talked me through some different strategies and avenues that I hadn't even thought of.
Yeah.
So I got the recoveries back in, even though I couldn't get that funding. So, you know, we're all from industry. We've had lots of years of experience between us, either in the legal industry or as practitioners. We've got all sorts on our team. And, you know, we've been to a lot of mediations. We've been to a lot of hearings. We've done over 60 insolvent trade claims and breach of directors' duties claims. So we know what the pleadings look like. We know the sorts of evidence that has to go in, all the sorts of things that might pop up along the way.
Yeah.
We can help with that, and we can help, you know, crafting and formulating strategies, but also, you know, looking at the documents and picking out, well, I think you should go a bit harder on this because the last time we were before this judge, this happened. And so there's that value as well.
So much knowledge.
Yeah. So just picking up the phone and having a discussion, even if, you know, you've got 10 grand of FEG and you don't think that we're going to be able to look at it because it's not commercial, you can still pick our brains and get us to help out with that strategy, and we can talk things through. So,
Absolutely.
And at the end of the day, hopefully we resolve matters quickly.
Sure.
That's great. But sometimes we're in this with you guys for years. These funded matters can go on and on and on. And so we pride ourselves in being a part of the team.
Yeah.
Being hopefully a pleasure to work with.
Yeah, no, definitely that. I haven't had to have too many tough conversations with you ever, I don't think.
No.
You just do all the right things.
Tried to.
Courtney and I went to a mediation probably a month or two ago, and every time we walked out of the room and we came back in and we had these big smiles on our faces, and the lawyer goes, so what's happened? What's the latest? And we say, no, nothing. We just really love our job and we enjoy being here, and that's why we're smiling. So yeah, I think it's working with good people and having a good time with it as well. You've got to enjoy what you do.
Absolutely.
And we definitely do. We've got the best job in the world, we think.
Absolutely.
Amazing. Well, thank you so much for your time, guys. I really appreciate you taking the time to come down and making the effort to come on today. So enjoy the rest of your day, and I'm sure we'll catch up sometime soon. Thanks again.
Thanks, Andrew.
Thanks for tuning in to Cathro & Partners The Cut. We hope you've enjoyed today's episode. For more insights, please visit our website, cathropartners.com.au, or find us on LinkedIn.